All right, this is in the matter of the people of the state of Michigan versus Tyler James Bice, file number 22-20975FH. I have Dawn Van Duzen appearing on behalf of Mr. Bice, and I have Christopher Fleming appearing on behalf of the people. This is the date and time set for pretrial. All parties have appeared via Zoom. So, Ms. Van Duzen, how do you wish to proceed with Mr. Bice?
Your Honor, in this matter with Mr. Bice, I'm going to ask the court if we could get a date, if you're available next week, that's not a Wednesday, because I'd like to talk to the court and along with the prosecutor at the same time.
Okay. So
it will be a plea, but it's just a matter of if it's going to be a cops or if it'll be a Killebrew.
Okay. All right. Miss Adams. You know, Miss Van Duzen, we have a really kind of a shorter morning, so I could do it at 11 today if you wanted.
Yeah, that would be perfect. Mr. Bice,
Right.
Are you available at 11?
Yes.
Okay.
All right. So Mr. Bice just zoom back in at 11 o'clock. Mr. Fleming, are you available?
It's Miss Beer's case. I'll let her know that it's on for 11. That should be fine.
Okay.
I don't see any issue with that.
Excellent.
Okay,
Thank you.
thank
All right.
you.
We'll see you at 11, Mr. Bice.
Okay, thank you.
All right. I have a gentleman in a blue shirt. Your device says Rose, but what is your name?
Peter Canella.
Say it again for me.
I'm sorry.
Can you repeat that again?
Oh, Peter Canella.
There you go. All right. So I'm going to change your screen name. And your attorney is Mr. Mawad, correct?
No, that's correct.
All right. So I am going to add his name. He should be here shortly. And we will, I'm going to put you in the waiting room and I'll bring you back in when Mr. Mawad gets here, okay?
Okay.
Thank you. All right, Mr. Goldstein, good morning. You have Taylor
morning.
Posey. All right, so is Taylor Posey in the courtroom? No. All right, so Mr. Goldstein, I do not have Mr. Posey in my waiting room.
I'll give him a call, Judge.
Okay. And Taylor Terrio in my waiting room. So Ms. Van Duzen, I don't have Ms. Terrio either in my waiting room or in the courtroom. All right. Is there anybody in the courtroom that is a defendant in a case today? You're in the back row. What are you here for?
Hearing pretrial.
Okay, what is your name?
John Barry III.
John Barry III. Okay, and your attorney is Mr. Fry. Okay. Anybody else? No.
Ahmed Al Mohammed.
Oh, okay. Yep. All right. Rhonda is your attorney. So she's next door. So if you want to just hang out for a minute, she'll be with you. Okay, Mr. Glazier, I think I only saw one case for you. You have Mr. Kuhn.
Yes.
All right, Miss Adams, could we get Mr. Kuhn from the jail?
Okay.
Mr. Fry? I do have Mr. Berry here in person. Hold on, I just got Taylor Terrio too. So Miss Van Duzen, I'll take care of Miss Terrio and you can go on down to the other court.
Thank you, Your Honor.
Miss Terrio, can you hear me? Connected. She's connecting.
Downstairs, house 9.
I'm sorry?
Y'all still calling nine?
What's your name?
Say y'all calling nine. I was downstairs.
What's your
That's
name?
Taylor- That's Mr. Posey.
Okay, have a seat, Mr. Posey. Thank you. Ms. Terrio, can you unmute your device, please?
Yes, I'm right here.
Okay, Ms. Van Dusen, this is in the matter of the people of the state of Michigan versus Taylor Ray Terrio, file number 2021-20257FH. I have Dawn Van Dusen appearing on behalf of Ms. Terrio, and I have Christopher Fleming appearing on behalf of the people. So, Ms. Van Dusen, how do you wish to proceed today with Ms. Terrio?
Well, Ms. Terrell, Your Honor, we plead not guilty. We asked for a pretrial set out next month. She has a new case that's possibly going to be charged against her, so we're just waiting for that, Your Honor.
All right, so I will set this out for another pretrial on May 31 at 8:30 in the morning. And Ms. Van Dusen, you'll do the stipend order to adjourn. Mr. Fleming, can she sign your name with permission?
Absolutely. Thank you, Judge.
Thank you,
All
Judge.
right, so Ms. Terrio, same Zoom number, and we'll see you back on May 31 at 8:30 in the morning.
Judge,
Thank
I'll see you at 11 o'clock.
All right, thank you.
Thank you.
Mr. Posey, you want to come up to the podium? Get your file. All right, so this is in the matter of the people of the state of Michigan versus Taylor Reed Posey, file number 22-20755FH. I have David Goldstein appearing on behalf of Mr. Posey, and I have Christopher Fleming appearing on behalf of the people. Mr. Goldstein, this is the date and time set for pretrial. How would you like to proceed today?
Your Honor, according to my notes, it's a final pretrial, but I could be wrong about that.
All right, probably not. I never get you wrong. So,
Because we have a trial date coming up.
Yep, so we are set for trial on May 9th for 2 days. Miss Adams, is this the primary trial on that day?
Yes, Judge, that is the only one set for that day.
All right. So yes, today is also the deadline for any motions. What your questions and jury instructions due. So
I'll tell you what, Judge, if we're continuing this to trial, can we pass this for a second? Miss Muir was requesting that David give her a call regarding this. She wasn't
Okay.
that they,
able to get a hold of you yesterday there.
Okay.
so Mr. Goldstein, do you have time to give Miss Muir a call?
Sure. This is the only thing I
Okay.
have this morning, Your Honor, so it's not a problem.
I mean, if she pops in, if she pops
She's
in,
in
I
Judge
can put
Old's
them in break.
favors.
Okay, all right,
I'll send her-
so
I'll
she
send her
can
a
still
text.
talk to you.
Perfect.
I'll send her a text, Chris.
Who's that?
Perfect. Thanks, David.
Okay, so Mr. Posey, just have a seat and we'll be with you in a minute, all right?
Who that they talking about?
So Miss Muir is the prosecutor handling this file. Miss Muir asked to speak with Mr. Goldstein. So Mr. Goldstein's going to reach out to Miss Muir.
Like a
right?
plea or something?
I don't know, because I'm not your attorney. So if you just want to have a seat when we come
I'm
back.
finna fire him today. I'm saying ready to fire him, but I see what's going on.
Mr. Posey, I'm not going to talk to you about this, so have a seat. If a prosecutor asks to speak to a defense attorney,
All right.
they have to speak to them. So
Yeah, man.
you just sit down and we'll be with you shortly. All right, got the gem out, Mr. Butcher. Let's see if there's anything in that. Mr. Fry, while I'm waiting for the jail, I do have Mr. Barry. Mr. Barry, come stand up at the podium. All right, this is in the matter of the state of Michigan versus John Wilson Barry, file number 21-20370FH. I have Brian Fry appearing on behalf of Mr. Barry, and I have Christopher Fleming appearing on behalf of the people. This is a date and time set for pretrial in this matter. Mr. Fry, how would you like to proceed?
Your Honor, if I could have a chance to talk with Mr. Barry, I've had discussions with Mr. Fleming this morning, and there's been a new offer that I haven't had a chance to talk to Mr. Barry about.
Okay.
Call me in the
So,
hall.
Mr. Barry, I'm gonna ask you to go out in the hallway and turn to the left, and you'll see an iPad on a stand. Follow the instructions. That'll help you zoom into my courtroom, and then I'll put you in a breakout room with Mr. Fry.
Okay, thank you.
You're welcome. All right, you can't stepping in the hall now. I have a jail room, I just don't have a body yet. All right, I have a gentleman joining me from the jail. What is your name, please? Mr. Kuhn, can you state your name for the record, please?
My name is Arturo Kuhn.
Thank you.
You're welcome.
All right, this is in the matter of the people of the state of Michigan versus Arturo Kuhn, file number 23-21317FH. I have John Glazier appearing on behalf of Mr. Kuhn, and I have Christopher Fleming appearing on behalf of the people. Hold on 1 second, let me let that break out or bring in Barry. All right. Connected to audio. Sending connection information to the hallway.
Things working fine. Thank you very much.
Could one of you that are here with Mr. Barry step out in the hallway? He needs to connect to audio, and I just sent him a chat. So maybe. I got it. Yep.
Excuse me?
Hold on, I'll be right with you. Hold on, I'm putting someone else in a breakout room. All right, now they're connected. All right, I just sent a request to join a breakout room. Mr. Barry, join the breakout room, and then when you're done, just come back in the courtroom. All right, so Mr. Glazier, how would you like to proceed today on behalf of Mr. Kuhn?
Your Honor, excuse me, Mr. Kuhn is going to plead to, I don't know if there's an amended information yet, but attempted CCW. And then he's also, part of the deal is he has to plead to an R&O downstairs in district court, which I think is coming up May 2nd.
He has to plead to what in district court?
It's a disorderly resisting and opposing.
Okay. All right, Mr. Fleming. So is that, so the plea offer is to plead to an amended information of count 2, carrying a concealed weapons. Attempted, which carries a maximum penalty of up to 2.5 years in prison and forfeiture of the device, along with up to a $2,500 fine, as well as a misdemeanor.
Yeah, the misdemeanor is pending in the district court.
Right, Mr. Fleming.
Yeah, that is correct, Judge, and I'm working on the amended information now.
And what is the misdemeanor? There's a disorderly R&O, or?
It's a resisted oppose. It's a ordinance violation for the city of Adrian.
Got it. So it's a 93-day misdemeanor and 90-day ordinance, right?
Yeah.
Okay, so Mr. Kuhn, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an amended information with a count 2, attempted carrying a concealed weapon, which carries a maximum penalty of up to 2.5 years in prison, as well as an ordinance resisting and opposing in district court, which carries a maximum penalty of up to 90 days. Now, you can't plead to the misdemeanor in front of me today. Mr. Glazier will have that set up to plead at your next court date in district court.
That's May 2nd.
May 2nd, but is it your intention to plead guilty to those?
Yes, ma'am.
Okay, can you raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. So, Mr. Kuhn, are you satisfied with your attorney and the advice that he has given you?
Yes, ma'am.
And other than the agreement placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct.
Mr. Fleming?
That is correct, Judge.
And is that correct as far as you're aware, Mr. Kuhn?
Yes, ma'am.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Kuhn?
I do, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? Do you understand that?
I do, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So, Mr. Kuhn, do you have any questions about the rights that I've given to you?
I do not.
Okay. So, Mr. Kuhn, how do you plead to the charge that on or about February 5th of 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of attempted weapons carrying concealed? Guilty or not guilty?
I plead guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, you're good.
Mr. Fleming?
No, Judge.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
All right, is it your own choice to plead guilty?
Yes.
All right, so Mr. Kuhn, were you in the city of Adrian in the county of Lenawee on February 5th of 2023?
Yes,
And at that time, did you have brass knuckles?
I did.
Where were they?
In my back pocket.
So would you agree they were concealed about your person then?
I do.
Mr. Fleming, are you satisfied with the plea?
People are satisfied, Judge.
All right, has the court complied with MCR 60302 B, C, and D? Mr. Glazier?
Yes, as
And
you.
Mr. Fleming?
Yes, Judge.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to
Your
the
Honor, he has a sentencing. Do you know when your sentencing is?
It was supposed to be yesterday, but I didn't. I didn't go, so I'm not sure when they pushed it back to.
Okay, hold on. Ms. Adams, could we look up and see when Mr. Kuhn is set for sentencing on his other file?
Okay. Is it a circuit court case, Judge?
He believes he was set for sentencing yesterday on it.
I'm not.
Yeah, I think,
We
Yes,
don't
ma'am.
do sentencing on Tuesdays. Do you have, so is it in front of me?
Yes, I had the paperwork. It was for the 24th, but not Tuesday. It was for the 24th a couple days ago on Monday. And we
I
never
don't
went.
do sentencing on Tuesday, that's
yes,
district court.
Mr. Daly represents.
Supposedly Mr. Daly is on it. Do you see another open file, Ms. Adams?
I'm looking through them.
If I may, Judge, I was just wondering if it would have been possible to have getting sentenced with everything all together. My recommendation for the last one.
Hold on, we gotta
Yeah.
find it first, so hold on one second.
Oh,
We're
Judge.
looking it up right now. We'll try to, yeah, of course, we'll do that with you. Hold on.
Judge, he is set for sentencing on April 28th at 8:15.
Oh, it's April 28th, okay. So Mr. Glazier, I don't know that I can get a PSI done.
That PSI is so new, we wouldn't object to you just using that PSI.
So, Ms. Teskey,
Yes, Your Honor.
okay, she sounded doubtful. All right. So today is the 26th, and Mr. Kuhn is set for sentencing on the 28th. So we wouldn't be able to get an update done, would we?
No. No, Your Honor. And we have to do a PSI. It cannot be waived.
Okay, so
we
the
have
only
to-
thing I would say, hold on, Mr. Kuhn. Ms. Adams, do you have the PSI for Mr. Kuhn in my office? Can I
Yeah,
see it real quick?
sure.
Hold on, Mr. Kuhn, let me see some. I think they're on my standing desk.
Do you know what the bond set at in this case before us right now, Judge?
It's no, but it's kind of where I was heading.
I thought so.
I wanted to see what his recommendation was. I don't know what his bond is, but I'm looking. Do you know? He's got like. It's got a $1,100 cash money. Hold on, let me see the PSI. Real quick. So hold on, Mr. Cohn. Worst case scenario. I must have hit my PSIs. Ms. Adams can't find them. Just a reminder,
Judge,
today's
I don't
administrative,
have that one. I'm not finding it.
really?
Yeah, I'm not seeing it.
Hold on. Just a reminder, it's administrative assistant day to day.
All right.
Don't forget your support staff. I'll be right back.
All rise.
Mr. Glazier, do you know if Mr. Kuhn has a bond down in district court? Or is it PR?
I don't think he does, Your Honor.
All right, Mr. Kuhn, do you have a PR bond down in
Oh,
district?
I don't think it is a PR.
You don't think he has a PR?
He didn't report to sentencing, so this is,
Okay, so Mr. Kuhn,
I had a report the sentencing due to me being back in Ohio with my mother. The time frame wasn't in my favor. We were too far away at the moment.
Okay. So Mr. Kuhn, here's what I'm gonna do. I have to move your sentencing because I can waive a PSI on violation reports, but I can't on new felonies. But what I can tell you is that when you go to sentencing on May 2nd, if you get released that day, if Mr. Glazier calls, listen, if Mr. Glazier calls up here and says, hey, Mr. Kuhn got released from jail today, I will give you a PR bond on my files, okay?
he won't get released from jail. Daley's file is still open.
I was gonna give him a PR bond on both of my files.
On both your files?
Yes.
Okay.
So here's the deal, Mr. Kuhn. I have you with Mr. Daly and I have one file with Mr. Glazier. So Mr. Glazier's asking, hopefully that I have to reschedule your sentencing, but I will release you on a PR bond if district court releases you. You got it?
Yeah, that would be great then. But
I don't have any control over district court, right? So
Okay.
if they give you a jail term, you keep getting credit on my case till sentencing. But if they give you if they release you from jail at sentencing, Mr. Glazier can call up and let me know. And then I will issue a PR bond on my two files, okay? But you'll still have to show up for sentencing, got it?
Will be there. I've got a lot more support this time than last time. I haven't been able to speak on my behalf, and I do apologize for the inconsistency that I had last time. My mother wasn't doing too well. She still isn't, but I've got better support this time than last time. And I just would like a chance to show that I can comply with the orders given to me by the court.
Okay, so I'm gonna set both of your files for sentencing on June 15th at 8:15 in the morning, okay? So we'll do both of your sentencings together. When and if you get released from jail, your jail paperwork will have your sentencing date on it that they give you, so don't lose it, okay?
Okay, I will not.
Okay. Now,
I apologize.
It's okay. If you, just, Mr. Glazier, you have him on May 2nd for sentencing, right?
I'm almost certain that's it.
So yes, so Mr. Glazier will let me know, but otherwise I'll see you back on June 15th at 8:15. Whether it's in person because you're not in jail or zooming from the jail. When you meet with probation, it's okay. When you meet with the probation department, be truthful about your background and the events that occurred. Miss Holly will do an updated PSI report and then she'll provide that to the court and Mr. Glazier. So one way or the other, I'll see you back on June 15th for both of them. So you won't be sentenced on the 28th, okay?
Okay, thank you. I appreciate it. Will I be seeing you later before then, or?
You'll see me on June 2nd.
Mr. Kuhn, if you are released, you need to report to probation ASAP.
I will report to probation. I have no reason not to report. Like I said prior, due to the inconsistency of the support that I thought that I had.
Okay.
Me.
All right. So I appreciate Mr. Kuhn. I appreciate that, and you're making it right now. So that's the important part, right?
Yes, ma'am. Yes, ma'am.
All right. So if you get released from jail on May 2nd,
I will be there at the courthouse as soon as it opens up.
Okay.
Judge, are you allowing him as part of his bond to go to Ohio?
Is that where he lives?
That's where I live, yes.
Yeah.
If I can find a place here, I'll stay in town. I don't have an issue
Okay.
with staying in
No,
town.
no. It's okay. If you live in Ohio, you live in Ohio. There's nothing I can do about that. But Mr. Kuhn, make sure you show up for sentencing.
Ma'am, I will be, and
Okay.
if I get released on the 2nd, I will be at the courthouse as soon as it opens up.
Okay. So if you get released on the 2nd, as soon as you can, report to the probation department. I will allow, his bond will allow him to travel out to Ohio if that's where he lives. Mr. Kuhn, make sure you stay in contact with your attorneys. And
Yes,
Mr.
ma'am.
Glazer will let me know on June 2nd whether you got released or
Yes, ma'am.
on May 2nd, Mr. Glazer will let me know if you've been released. And remember, your sentencing is June 15th at 8:15, all right?
June 15th, yes, ma'am. With my paperwork, would I be able to get your number, Mr. Glazer? But they send me over to the jail?
The public defender, the number should be on some of your paperwork.
I'll talk to you on May 2nd. That's next.
He'll talk to you on May 2nd.
All right, that's fine. I really do appreciate it. You guys have a wonderful morning.
Judge,
All right, you too.
Judge,
Thank you.
Yes.
Mr. Kuhn, is he still requiring in person he did for Friday for the sentencing?
No, I'm moving that sentencing to June 15th.
But is he still requiring that it be in person?
Yes, I'll be there in person.
Yeah,
Thank you.
okay, all right.
Thank you.
You're welcome. Thank you. All right, Mr. Mawad, I have Mr. Canella.
Yes, Your Honor.
Have you ever been to Canal in Detroit or Ann Arbor?
Canal, I think so, in Detroit, not in.
It's that really awesome French pastry shop on Woodward?
Yes, yes, what you just said, yes. Yep, you just remind, yep. I knew the name, it wasn't clicking into what it was, but yes.
Okay, all right, so Mr. Canal, can you hear me?
Elias, there's one in Ann Arbor. I'll meet you there anytime you want.
David, we'll bring Fleming with us too.
Okay, it's a deal.
You guys are buying.
All right, Mr. Canella, can you hear me?
Yeah, I can hear you.
All right, this is in the matter of the people of the state of Michigan versus Peter Alex Canella, file number 23-21299FH. I have Elias Mawad appearing on behalf of Mr. Canella, and I have Christopher Fleming appearing on behalf of the people. This is the date and time set for pretrial. Mr. Mawad, how would you like to proceed?
Judge, I did talk to Mr. Fleming a couple days ago and yesterday. I think what we'd like to do is just get the next available date. We should have this matter worked out in the form of a plea, if I'm right, Mr. Fleming. And I think you got my messages from yesterday. So hopefully that will work out if that's okay with Mr. Fleming in the court.
Well, here's what I'm thinking, Eli. I know back in March, what I was thinking was he's currently under the CMH mental health court order, Your Honor.
Yeah.
People are thinking that we'll dismiss with prolonged continued compliance with that.
Okay.
So I know according to Jenny Zadorsky at CMH, he was doing great back in March. So maybe we could adjourn a month or two. If he's doing great at that time, then we'll just dismiss if as long as he's continuing that.
How about June 21st, Mr. Mawad at 8:30?
That'll work with me.
All right, so June 21 at 8:30. So, Mr. Canella, I'm going to adjourn this to June 21 at 8:30 in the morning. So stay in contact with Mr. Mawad, okay?
Yes, sir, yes, sir.
Okay.
All right. Thank you, Mr. Canella.
And then can I sign Mr. Fleming's name to a stip? Will that work? Be okay?
Absolutely. Okay. Thank you, Eli.
All right. We'll see you and everybody else up in Ann Arbor soon.
I'll meet you there.
Right. All right.
Thank you all. Bye-bye.
Right.
Keep it up,
All right,
Peter.
Mr.
Thank you.
Canella, you're all set.
Okay, thank you.
You're welcome. Okay, Mr. Fry, got Mr. Wait, Mr. Goldstein, hold on. Mr. Goldstein, I
Yes, Your
do
Honor.
have Mr. Posey. Have you had a chance to speak with your prosecutor?
Yes, Your Honor, I sent you a text. We're waiting for amended information.
Okay, all right. Do you want him set up on a breakout room in the hallway to talk to him?
No, I just talked to him on the phone, Your Honor.
Oh, okay. All right. So, all right, Mr. Posey, give us just a moment. All right,
Good morning,
Mr.
Sarah.
Fry, let's bring Mr. Barry back up. All right, we're back on the record in the matter of the people of the state of Michigan versus John W. Barry III. I have Brian Fry appearing on behalf of Mr. Barry and Mr. Fleming appearing on behalf of the people. So, Mr. Fry, how do you wish to proceed with Mr. Barry?
Your Honor, I have spoken to Prosecutor Fleming and also my client about a possible plea resolution to this case. It's my understanding that a plea agreement has been reached where my client would plead to an amended count 2, which would be attempted larceny from a motor vehicle. The prosecutor would agree not to authorize a absconding charge for his failure to appear in this case, and there's a sentencing agreement to no further incarceration at the time of sentencing.
Okay, so two things. There are already 2 counts on this file. Count 1 is larceny from a motor vehicle. Count 2 is MDOP less than 200. So would it be an added count 3 on an amended information?
Sorry, yes, Your Honor, it would be an added count 3, and count 1 and 2 would be dismissed.
How old are you?
23.
Is he eligible to be considered for HIDA?
I think based on the age, he would be possibly eligible, but I would leave that to the court's discretion.
Okay. All right, Mr. Fry.
Yes, Your Honor, I think
Yeah.
could be a possibility and something we would be requesting from the court at sentencing.
Okay. All right, so Mr. Barry, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, can you state your full name for the record?
John Wilson Barry III.
Okay, so Mr. Barry, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 3, which is a attempted larceny from a motor vehicle, which carries a maximum penalty of up to 2.5 years in prison and or up to a $10,000 fine? Is that your intention?
Yes, Your Honor.
Do you understand that count 1 and count 2 would be dismissed at the time of sentencing, and then the people have agreed not to charge you with absconding?
Yes.
Okay. Now, and part of the agreement is that there would be no upfront jail at the time of sentencing, and you could be considered for HIDA.
Yes.
Right. The Homes Youthful Training Act is an opportunity for someone with no criminal record to successfully complete a term of probation, and then your record will never become public.
Okay.
So it won't impact where you live, where you go to school, anything of that nature. Do you understand that?
Yes, I do.
Okay. Now, are you satisfied with Mr. Fry and the advice that he's given you?
Yes.
Do you understand the maximum penalty for this offense could be up to 2 years in prison?
Yes, I do.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct? I don't know. Mr. Fry, what's your P number?
P76169.
Mr. Fleming?
Much lower, 75946, Your Honor.
All right. Is that correct, Mr. Fleming?
That is correct, Judge.
Is that correct, Mr. Fry?
Yes, Your Honor.
All right. And is that correct as far as your work?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that?
Yes, I do.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. So how do you wish to plead to the charge that on or about August 29, 2020, in the city of Hudson in the county of Lenawee, that you did commit the offense of attempted larceny from a motor vehicle?
I plead guilty, Your Honor.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is, that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming?
No, Judge.
Mr. Fry?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be other than no upfront jail?
No.
Okay. Zero on choice to plead guilty.
Yes.
All right. So, Mr. Berry, on August 29th of 2020, were you in the city of Hudson in the county of Lenawee?
Yes.
And then you and Mr. Bonnie, were you with Mr. Bonnie?
Yes.
All right. So, did you take some stuff from a car?
Yes, I took the radio.
Took the radio. And did you know who owned the car?
Yes.
And did they give you permission to take the radio?
No.
Okay. And did they, and when you took it, your intent was to deprive her of it, correct?
Yes.
Mr. Fleming, are you satisfied?
That motor vehicle and radio belong to Alyssa Hill, correct?
Yes.
Perfect. People are satisfied, Judge.
All right. Has the court complied with the MCR 6.302 B, C, and D? Mr. Fleming?
Yes, Judge.
Mr. Fry?
Yes, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, other than the Killebrew to no upfront jail in consideration of FIDA. I'm going to refer this matter to the probation department for a pre-sentence investigation. I will set sentencing for June 15th at 8:15 in the morning. Are you available that day, Mr. Fry?
Yes, Your Honor.
All right. All right, so, Mr. Berry, your sentence will be June 15th at 8:15 in the morning. You can appear in person or you can appear via Zoom. How do you want to be here?
Zoom. I'll do Zoom.
They said Zoom. Okay. So we'll schedule that for sentencing. Do you have our Zoom information?
Yes.
Okay. Now, I'm going to send you across the hall to check into the probation department. They're going to set up a time to meet with you. When you meet with them, be truthful about your background, be truthful about the events that occurred. They'll prepare a pre-sentence report. I'll provide that to Mr. I will not. My staff will provide that to Mr. Fry, who will review it with you before sentencing. And we'll see you back here on June 15th at 8:15 in the morning via Zoom. All right.
Okay. Thank
So
you.
just straight across the hall, the probation. Thank you. All right,
Thank you.
Mr. Goldstein, Mr. Goldstein, I don't. And Mr. Fleming, you'll provide that amended information today, correct?
Absolutely, Judge.
So, Mr. Goldstein, I can proceed. They'll provide the amended information to me.
Yeah, Ms. Mears said she's working on it.
Can I ask what the offense date was for Mr. Berry, please?
Yes.
I'm signing the amended right now. It states August 29th, 2020.
Thank you. You're on top of it.
I have my moments.
Don't, yeah, don't give him too many compliments.
I will.
All right, Ms. Brenner, I'm looking, you're on Brandon Brigman.
Good morning, Judge.
Ms. Underwood, I don't have Mr. Brigman. Do you want to try calling him?
Uh-oh. Rhonda?
I actually just did try, Your Honor. His voicemail is full.
I hate when that happens.
Your
All right,
Honor,
by
he's
the
still
way-
paying his child support, so I'd agree to a brief adjournment if we want to try to track him down.
Okay. All right,
And-
how about my next available date is May 31. Is that all right?
That's fine.
In the
May
matter of the people
31?
of this, yep, in the matter of the people of the state of Michigan versus Brandon Ty Brigman, 2021-20566FH, and Ron Underwood appearing on behalf of Mr. Brigman and Sarah Brenner appearing on behalf of the Attorney General's office. Mr. Brigman is continuing to make his payments, and Ms. Brenner has no objection to an adjournment. My next available is May 31 at 8:15 in the morning. So Ms. Underwood, you can prepare the stipend order. Can she sign your name with permission, Ms. Brenner?
Yes, Your Honor, thank you.
All right, and Ms. Brenner, the Tina Turner thing at the Wharton Center was awesome, by the way.
It was very good.
All right, you're all set, Ms. Brenner. Thank you.
Thanks, have a
Thank
great day.
you.
You too. Okay, so let's see if this. Miss Underwood, I got, Miss Adams, could I get Xavier Santiago from the jail? Mr. Posey, just be a few minutes, okay? And then, I do have Mr. Muhammad here.
Thank you, Your Honor.
Sir, you want to come up to the podium? Okay, this is in the matter of the people of the state of Michigan versus Ahmed Abdul Kareem Al Muhammad, file number 22-21166FH, and Rhonda Underwood appearing on behalf of Mr. Al Muhammad, and I have Alexander Banetto appearing on behalf of the people. Your client was here right on time this morning, Ms. Underwood, but I explained that you went to Judge Olsaver's court first, so I appreciate your patience this morning. So this is the date and time set for a pretrial. Ms. Underwood, how do you wish to proceed today?
Your Honor, we have ordered the preliminary exam transcript. We don't have it yet. So I would just ask for an adjournment of probably a month, maybe. Give us a chance to get that.
Okay, when was the preliminary exam?
I can answer that, Your Honor.
Well, they have 90 days to complete the transcript, so do you want me to set this out to like, I don't know, how about June?
That would
And
be
see-
fine, Your Honor.
All right, and Miss Adams, could I get a notice for him because he is present in person? So I'm going to set the next pretrial for June 21 at 8:30 in the morning. So, sir, you're waiting for a transcript from your prior hearing in district court. So I'm setting another date for June 21 at 8:30 in the morning. You can Zoom in or you can come in person, however you'd like. Do you have our Zoom instructions?
Yeah, I would, I'm only actually a couple blocks down on Locust, so I would rather probably just come in
That's
first.
not a problem. So just have a seat and we'll get you a notice of hearing, all right? So you won't have to do the notice on that, Miss Underwood, all right? All right, so. I do not have an MDOC, Ms. Underwood, for Mr. Pagan.
That was my next question, Your Honor.
All right, I do, let's see, I don't have Matt Murphy. Martin, give me a word name. I do have a Mr. Martin in my waiting room though. All right, Mr. Malaro. Thank you, have a good day.
Yes, Your Honor.
Speaking of your client, Mr. Pagan, Ms. Underwood, you know, we have big horse race next weekend, so my money is on Mage, by the way, but Mr. Malaro, I do have Mr. Martin.
Okay.
Mr. Martin, can you hear me?
Yeah, I can hear you.
All right, this is in the matter of the people of the state of Michigan versus Matthew Dean Martin, file number 21-20466FH. I have Salvatore Malaro appearing on behalf of Mr. Martin, and I have Christopher Fleming appearing on behalf of the people. Looks like this is the date and time set for pretrial motions. So, Mr. Malaro.
Have reached a plea agreement.
Okay.
I could place it on the record.
Please do.
So, Your Honor, Mr. Martin is going to plead no contest to an added count 3 attempted conspiracy to commit breaking and entering with intent as a 5-year felony. In exchange, counts 1 and 2 will be dismissed. The habitual offender will be dismissed. The guilty plea will be subject to a Killebrew agreement where the Mr. Martin shall serve no immediate jail or prison sentence and shall receive a delayed sentence under MCL 771.1. The basis for this is that in related offenses, Mr. Martin had previously pleaded guilty and received HITA and was successfully discharged from those. That is our plea agreement, Your Honor.
All right. Is that correct, Mr. Fleming?
Judge, I don't see that in the notes. Can we do this? Can we pass this for 1 second? Let me try to get the amended info to you and I'll confirm with Isaac regarding
Judge, I can text the plea offer to Mr. Fleming as we speak.
That would be perfect.
Screenshot of Mr. Sneed's text to me.
Yes.
I still don't have an amended information yet. Oh, wait, this is for. That's what, okay. So while, Mr. Malaro, while you're doing that, I'm going to skip over to Mr. Goldstein because I have received an amended information. So Mr. Posey, you want to come up to the podium? So let me take care of Mr. Goldstein. Okay, Mr. Goldstein, I have received the second amended information. So in the matter of the people of the state of Michigan versus Taylor Reed Posey, Mr. Goldstein, would you like to, let me see if I put the record. No, Mr. Goldstein, would you like to now put the plea offer on the record?
Yes, Your Honor. The people have filed an amended information which adds a count 4 of stalking, which is a 1-year misdemeanor. Mr. Posey is going to plead no contest to count 3, which is a domestic violence, which is also a one-year misdemeanor, and the added count 4. The reason for the no contest plea is for the potential for civil liability. There is an agreement that counts 1 and 2, the 2 felony charges will be dismissed. We also have a sentencing agreement that Mr. Posey will receive no upfront jail in these cases. But the terms and conditions of probation will be up to the court.
Okay, okay. So, Mr. Martin, I get some feed from your device, so I'm just gonna pop you in the waiting room for a moment, all right?
Okay.
All right, thank you. Okay, so Mr. Posey, you wanna raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Good enough.
Okay, so Mr. Posey, you heard the statement of your attorney. You can put your hand down. Is it your intention to plead no contest to count 3 domestic violence, which carries a maximum penalty of up to 93 days in jail and or a $500 fine, as well as count 4 stalking, which is a 1-year misdemeanor and can carry up to $1,000 in fine or up to 5 years probation, with the understanding that there will be no upfront jail. So when you come in for sentencing, there will be no jail at that time. So is it your intention to enter into that plea agreement? Do you have a question for me? Sure. Okay. So
You decide my term of probation today?
no, so we have to set it for sentencing. And so you'll meet with district court probation and they'll make a recommendation. And then at the end of the day, it's up to me. But, I'll honor the agreement. You're usually looking at 1 to 2 years probation, some fines and costs, no contact with the individual with the initials of KT. So stuff like that. Okay? Do you have any more questions? Okay, and if you have a question, just raise your hand, okay? All right, now, are you satisfied and you understand you're entering a no contest plea for civil liability? Right? So if I ask you how you plead to something, you would have to say no contest, okay? All right, are you satisfied with Mr. Goldstein as your attorney and the advice that he's given you? Okay, and neither, other than what was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any possible sentence in terms of probation and fines and costs. Is that correct, Mr. Goldstein?
Yes, it is, Your Honor.
And Mr. Fleming?
That is correct, Judge.
And would you agree with that as well, Mr. Posey?
Yes, ma'am.
Okay. If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them, okay? You do have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial, which means I would make the decision. You have a right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes, ma'am.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? Okay, so Mr. Posey, how do you wish to plead to the charge that on or about January 24th of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense of domestic violence? Okay, and how do you plead to the charge that on January 24th of 2022 in the city of Adrian in the county of Lenawee that you did commit the offense of stalking? Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge? Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea? Do you understand that? Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Goldstein?
No, Your Honor.
And Mr. Fleming?
No, Judge.
All right, so you, yes, sir.
I have one question.
Sure, can you step up to the,
When you said no upfront jail, do that mean like when I get sentenced, you still like get send me to jail?
No.
That sense.
no, what it
So,
means
I
is
just-
that when we come back for sentencing, even if they make a recommendation of jail, I will honor the agreement and there will be no upfront jail.
So it'll just be like upon like completion of probation, then I go to jail. If I
No.
don't complete.
So, okay, so when we come to sentencing, I'm not gonna put you in jail.
Right,
If you successfully complete probation, you'll never go to jail.
right.
But say if I put you on probation and then you violate probation, I could give you jail then.
Right.
But as long as you do what you're supposed to do, you're not gonna go to jail.
Right.
Got it? Okay. In this case, there's a pretty concise and clear sentencing agreement, but your attorney hasn't promised you what your fines and costs would be your term of probation, right?
Yes, ma'am.
He hasn't told you what it.
No,
would be.
ma'am, that's
Okay.
correct.
All right. And is it your own choice to plead no contest?
Yes, ma'am.
All right, so Mr. Fleming, will you be placing the factual basis on the record? Or do you want
I
Mr.
would defer to
Goldstein?
Mr. Goldstein on that. I mean, I think a police report was submitted, Judge, if.
Yeah, Ms. Mears said she sent a police report over to you, Judge.
I don't have it.
Your Honor, let's then, for purposes of the record, I would indicate I have reviewed the police report and I am satisfied that were this matter to go to trial, the people could prove that on the date and set forth in the information in the city of Adrian, county of Lenawee, that Mr. Posey committed an assault upon Katrina Taylor. I believe it's Taylor. I'm sorry.
Can we
Taylor.
use initials? Can we use initials now?
Sure. Okay, it's KT, Judge. And with a woman that he had a dating relationship with, and that he continued to contact her after she asked him not to. And in fact, I believe there was a PPO issued.
So what was the assault as described in the police report?
That he put his hands on her shoulder and then on her neck.
Okay. Mr. Fleming?
I believe that would suffice for the assault. As far as the stalking, I think that would, let me just make sure, but I think that's fine.
So Mr. Goldstein, there was a PPO in place and he continued to contact her?
Yes, Your Honor.
Can't say anything because you pled no contest.
You can't say
Okay.
anything.
Okay, and that continued contact would have made a reasonable person feel frightened or intimidated.
Yes, Your Honor.
Okay.
Yeah.
Mr.
And that's what
Fleming,
the police report indicates, Adrian Police Department Report 2200000772.
Hello?
Stipulate to that.
Yes?
Hold on, I'm gonna mute. Mr. Goldstein, can you mute yourself?
And it would indicate further that there was a PPO in place with the victim by the name of JT initials, or excuse me, KT. And there was continuous contact after that PPO was issued, and that contact caused a reasonable person to feel terrorized, frightened, or intimidated, or threatened, or harassed. And it did cause KT, excuse me, to feel terrorized, frightened, intimidated, threatened, or harassed.
Okay. So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on January 24th of 2022 in the city of Adrian in the county of Lenawee, that the defendant did in fact commit the offense of domestic violence and stalking, and that he did make an assault upon the individual KT by placing his hands on her shoulder and her neck, and without permission, and she was an individual that he had a dating relationship with, and that police or a PPO was set in place at some point, and after the entry of the PPO, Mr. Posey did continue to contact KT in such a way that a reasonable person could have felt terrorized, frightened, intimidated, or threatened, or harassed. And in fact, she did feel that way. Therefore, the court accepts the no contest plea. Has the court complied with MCR 6.02 B, C, and D, Mr. Goldstein?
Yes, Your Honor.
And Mr. Fleming?
Yes, Judge.
All right, the court has made many agreements, but not all agreements regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. So I'm going to set this matter for sentencing. Mr. Goldstein, are you available June 15th at 8:15?
Yes, Your Honor.
All right. Ms. Adams, could I get a notice for Mr. Posey with an instruction to report to district court probation between 8 and 10 a.m. on May 4, please?
Okay.
Thank you. All right, so Mr. Posey, I'm gonna get you a notice of hearing for sentencing. You can come in person, you can Zoom, whatever you choose. I'm also going to instruct you to report to district court probation, not this week, not tomorrow, but next Thursday between 8 and 10 a.m. Okay. Now, you entered a no contest plea, which means that you don't have to answer any questions, or you shouldn't answer any questions about the events that occurred. Do you understand that?
Yes, ma'am.
Okay, so you can be truthful with them about your background, but because you entered a no contest plea, you do not have to make a statement about the events that occurred, okay? And you can tell them the judge said that, all right? And then they'll prepare a report. We'll get that report. We'll send it to Mr. Goldstein, and Mr. Goldstein will review it with you before sentencing that morning, okay?
Yes, ma'am.
All right, and do you have any questions?
So sentencing in May the 4th?
Sentencing, no, I'm gonna get you a notice. Sentencing is June 15th at 8:15.
Okay, June 15th.
But I need you to report to district court probation on May 4th between 8 and 10. But we'll get you a piece of paper that says all that.
Yes, ma'am.
Okay? Do you have a child in common with her?
Okay.
Good, okay. But remember, you can't have any contact with her.
I ain't. That
Even if she-
PPO was before the case too.
Okay, but I don't care if she shows up buck naked on your porch. You understand? You keep that door closed and you call the police, right? Okay. You see her somewhere, you go the other way, right? Because you don't want to get in trouble now.
No, man.
Okay, all right, have a seat there and we're gonna get you a notice of hearing, all right? All right, thank you. Yes, ma'am.
I'm sorry, I missed it. Did he want Zoom or in person for that?
Do you want to come in person or Zoom?
Yeah, I'll come in person.
He'll come in person.
Okay, thank you.
All right, Mr. Goldstein, anything else?
Nothing. Thank you, Your Honor.
All right, thank you, Mr. Goldstein. Okay. Bring Mr. Martin back in. Oh, so I lost Mr. Mulbauer. Okay. Mr. Martin, I lost Mr. Mulbauer for a minute, so just bear with us and keep yourself muted, okay? All right. And I still, Miss Adams, I can get Mr. Santiago from the jail whenever you have a chance, because I know you're doing something else right now. All right, Miss Adam, or Miss Underwood. Rhonda Underwood.
Yeah.
Great. So that'll have both days you need to do those things, okay? All right, you're all set.
Yeah, you too.
All right, while we're waiting for everybody, Jeff, we're gonna take a quick break. Oh, never mind, Ms. Underwood's back.
Gotcha.
Your Honor,
Yes,
on Mr. Pagan, what are we gonna do with Mr. Pagan today?
I know we like to say pagan, but it's pagan, right? He always corrects me, it's pagan.
I apologize then.
I know, I like pagan, but anyway. In the matter of the people of the state of Michigan versus Ricky Lee Pagan, file number 22-21142FH. I do not show that we have a writ from the prosecutor's office for him. So the last writ I have in my file is for March 15. So I don't know if there's another one out there. I don't always have everything up to date in my file. So I can set this for another day and have the people do another writ.
Thank you, Your Honor. I do see that Mr. Pagan is actually going to be seen by the Forensic Center today, I believe via Zoom, for his criminal responsibility. So that should move things along a little bit.
Nice.
So if we could have a new date.
How about we set this over to May 31? Because if they've already done the competency, they should be able to kick out the criminal responsibility pretty quick, don't you think?
Well, they've been really delayed on criminal responsibilities, Your Honor.
Okay, how about June 14th at 8:15?
Thank you, Your Honor.
All right.
Would you like me to do the stipend adjournment?
No, we'll let Mr. Fleming's office do this in order to adjourn along with the writ.
Oh, thank you.
You're muted, Mr. Fleming.
Well,
I have no problem doing the stip and order, Judge. What date did you set that for, though?
Oh, gosh, June 14 at 8:15.
And Miss Underwood, do we have your permission to sign that stip and order?
you most certainly do, Mr. Fleming.
Perfect. Thank you, Miss Underwood. Thank you, Judge. We will get that done ASAP.
All right, you're the best. Thank you. All right, Miss Underwood, speaking of missing people, in the matter of the people of the state of Michigan versus Jason with an I, Scott Wright, file number 22-21032FH. Mr. Wright is part of the economic diversion program, and this is the date and time set for contempt arraignment and pretrial. Is this a new file? Yep. So it looks like we have a motion affidavit and bench warrant for failure to appear for pretrial March 8th. Is he in jail?
That's what I was wondering too, Your Honor, because I just tried to call him at the number we had, again.
So it
But I
looks like
don't,
we picked him up and he has a $40,000. Oh, no, I don't know. Becky, we'll have to check to see if Mr. Wright is in custody.
Judge, it looks like you changed his bond to 810 and that was posted.
It looks like he posted his bond.
I suspect the bond was what he owed for diversion, Your Honor.
Mr. Fleming?
People would, of course, leave it in your honorable judge's discretion here.
Is that all he owed on the diversion program? Was the 810? Like, did he pay that off?
I'll tell you what, let me talk with Bob on that one real quick, Judge.
Okay, all right. All right, so Mr. Santiago,
Yes.
good morning.
Good morning.
Very fun. All right, this is in the matter of the people of the state of Michigan versus Xavier Santiago, file number 2018-18950FH. This is a date and time scheduled for a violation of probation pretrial. Ms. Underwood was appointed to represent him and had requested that it be adjourned to today's date for a pretrial. So Ms. Underwood, do you need a moment to speak with Mr. Santiago?
I do, Your Honor. Thank you.
All right. So Mr. Santiago, I'm going to open up a breakout room.
Okay.
Put you and Ms. Underwood in it. And then we will take a brief recess.
Will I hit join?
Yep, go ahead and join.
Okay.
Just me. Okay. Wait, one minute. I look on the monitor.
86 to 91. She's a great help.
Right, Mr. Malaro. Mr. Malaro's back, Mr. Martin, so I will take care of your case. So let's get Mr. All right, Mr. Malaro, we are back on the record in the matter of the people of the state of Michigan versus Matthew Dean Martin. File number 21-20466FH. Mr. Malaro represents Mr. Martin and Christopher Fleming on behalf of the people. I have received a felony information that's been amended, Mr. Malaro. So what is the plea offer in this file?
Judge is going to plead to the added count attempted.
Is it a no contest to count 3?
Yes, added count 3, attempted conspiracy to commit breaking and entering with intent, counts 1, 2, and the habitual will be dismissed with a killabrew. Agreement of no jail or prison and a defer or delayed sentence under MCL 771.1. As I indicated earlier, he had a successful completion of HIDA.
Mr. Martin, want to raise your right?
These are related offenses.
Okay. Mr. Martin, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. So, Mr. Martin, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest to count 3, attempted conspiracy to breaking and entering a building with intent, which carries a maximum penalty of up to 5 years in prison and or a $5,000 fine? There is a killabrew, no upfront jail with the delayed sentence, and count 1 and 2 would be dismissed, as well as the habitual offender notice. So is it your intention to plead no contest to that count?
And
Sorry, I
somebody,
didn't hear you.
I'm sorry. All right, Ms. Chesky, can you mute, please?
yeah, I just need some, I didn't catch that entire plea agreement.
So he's going to plead to count 3, attempted conspiracy to breaking and entering, which is a 5-year felony.
Okay.
There is killabrew agreement to he's going to plead no contest.
Okay, I caught the rest of that. I just didn't catch the added charge.
Okay, yep, it's coming through. Okay, so what was I going to ask next? Are you satisfied with your attorney and the advice that he has given you, Mr. Martin?
Yes.
Okay. There's pretty comprehensive agreement on the record, but other than that, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Malaro?
That is correct, Judge.
And Mr. Fleming?
That's correct, Judge.
Is that correct as far as you're aware, Mr. Martin?
Yes.
Okay, so I always, so they've changed a lot of this. So this is a delayed sentence, not a deferred sentence. Under a deferred, the judgment of guilt is not entered and Mr. Coast supervises on probation. But on a delayed sentence, the judgment of guilt is entered. We supervise under a delay. Ms. Teskey, so would your office monitor that, or would it still be Mr. Coast?
It still is Mr. Coast, Your Honor. We just had a case like that. In that case, your office put on at the sentence the delay, you put on the judgment that he is to be supervised by Mr. Coast, and that's how
I just want to make sure.
Yep.
All right, so Mr. Martin, If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. Ms. Adams, if you could see if Mr. Coast can log in.
Okay.
Sir, you have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. And I think I lost my place a minute ago. So Mr. Martin, I'm not sure if I asked you this. You heard the statement of your attorney, the prosecuting attorney, and what I put on the record. Is it your intention to plead no contest to count 3?
Yes.
Okay. I just can't remember if I asked it or not. All right. Mr. Coast, I'm taking a plea on Mr. Martin, and then it will be a delayed. So at the end of it, I can put him in a breakout room with you.
Sounds good.
So he's pleading guilty to an attempted conspiracy to break and enter, which is a 5-year. We'll get you that information.
I'm sorry, judges, no contest.
Or no contest, he's pleading. All right. So, Mr. Martin, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
You are not a citizen of the United States of America. A conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Mr. Millar, can I ask a question of you and Mr. Fleming? Did you say that this event occurred at the same time the events he had a HIDA for?
Yes.
So why aren't we just doing a HIDA with 1-year probation?
I'm okay with that too.
Mr. Fleming?
I would not object to either way, Judge. I think it's 6 in one hand, half dozen in the other at that point.
Do you care, Mr. Martin?
Probation. I got the HIDA program.
You're going to be on probation both ways. So, you know, if you'd rather do the delay, that's fine. You'd rather do the delay?
Judge, we can do the HIDA. I would prefer that if we can do that.
Would I be on probation for a year?
You're going to be on probation both ways. It depends on whether you're on probation across the hall or you're on probation directly with me and Mr. Coast.
Because this wasn't the plea agreement I got told.
No, it's not. But it might have been easier for you. This is the reason I'm asking. But do you want to continue with the way it is?
Well, I just need to be able to go out of state for work.
Judge, can I explain it to him real quick in a breakout?
Yeah, go ahead. I mean, it's really doesn't matter at the end of the day, but it might be easier. So hold on. So I'm going to put Mr. Millar and Mr. Martin in a breakout room. Post-it notes so I don't forget where I was. Okay. All right, Ms. Underwood with Mr. Santiago.
Yes, Your Honor.
An opportunity to speak with.
May I speak, Your Honor?
Your Honor,
hold on.
can I
Hold on. Everybody stop talking over me. I know you can't hear Mr. Santiago, but listen. Ms. Underwood, I placed you in a breakout room with Mr. Santiago. Were you able to speak with him?
I'm sorry?
I put you in a breakout room. Have you been able to speak with Mr. Santiago?
Yes, Your Honor. I've explained to Mr. Santiago that he has a violation with 3 charges, Your Honor. And Mr. Santiago currently has a case in district court concerning 2 of those charges. And that case is set for a settlement conference on June 26th. Now, it's my understanding that Mr. Santiago has a PR bond on that case. Is that correct, Mr. Santiago?
Yes, and I would like to plead guilty for my drinking violation, please.
Oh, hold on. She's getting to the good part right now. So hold on. Go ahead, Ms. Underwood.
So what I was going to ask the court is if, since the violation does contain 3 charges, if Mr. Santiago could be released on a no contact bond, mirroring what he has in district court, to await the outcome of that and deal with his violations properly. Mr. Santiago wishes to enter a plea on a partial, on the 1 charge, Your Honor. And
Okay, what is he charged with in district court?
I believe it's a domestic violence, Your Honor.
Judge,
Okay, yes.
I would like to get the assigned agent for this violation. I would like to get her on. I don't want to speak for this case without her.
Okay.
So can we wait just 1 second to get her on here?
Yeah, it's Joanne Holly. All right, so Mr. Santiago,
Yes,
you have a domestic violence charge down in district court, right?
yes.
Okay, do you understand that that case has not been heard yet by the district court judge? And down there, you could be facing up to a year in jail. Do you understand that?
Yes, I would like to plead guilty for my drinking violation.
Let me talk. So what Ms. Underwood is trying to explain to you is that if you make any admissions on a violation of probation in front of me, it's a court record. Sarah, you're not muted. So if you admit to any of these violations, they can use that against you in district court. Do you understand that? Mr. Santiago, do you understand?
Yeah.
Anything you say in my court can be used against you to convict you in district court. Do you understand that?
Yeah, I'm just here for drinking.
No, you're not. You're here for 3 things. So
I know I gotta know the charge, but I'm not too worried about it.
just
I'm
couldn't
just
hear
here for
any
the
of that.
violation, Your
I
Honor.
can't hear you. I can't hear you. Scoot up a little bit and speak a little bit slower.
I understand that I have another charge downstairs, but what's holding me here right now is the violation. I would like to plead guilty for the drinking violation and time served. I've been here for 60 days. So I can start paying on my court fees and all that.
I can't hear you. You're breaking up and it's not your fault. It's not your fault. It's the room you're in. The more you move, the more it breaks you up. So you have 3 violations in front of me. You don't get to pick or choose which one you plead to. You have
But I'm
3
only guilty
violations. It is alleged, let me talk. It is alleged that you violated the terms of your probation by assaulting an individual, NZ, hitting her on the head several times, spitting on her, grabbing her hair, pulling her around, per the police department report. It also is alleged that you consumed alcohol below 0.08. It's also alleged that you were residing with NZ by the Adrian Police Department on 2/16 when you're not supposed to be. So do you understand, if you plead guilty to any of those, that could be used against you in district court?
Yes, I know, and that's why I'm going to court to beat these charges. I'm only guilty
Well, you
for
can't meet the charges if you plead in front of me. If you plead in front of me today to all 3 of these.
I just want to plead guilty to the drinking.
Well, you don't get to choose which one you plead.
That's
to.
crazy, man. Like, so y'all forcing me to plead
Crazy,
guilty
but
to all
it's
of
my
them.
world. So you either plead guilty or not guilty. But
Here for my violation.
are you gonna plead guilty to all 3?
No.
Then I will enter a plea of not guilty on your behalf. And I will set this for a mock trial on, it is. Ms. Underwood, when was court date in district court?
I'm sorry,
When is your district court date on the domestic?
I believe that's way in June 26th for the
All
settlement.
right, Ms. Adams, I need a trial date, please.
You're forcing me. Last time it was cool though. That's crazy.
How far out do you need that, Judge?
Next available violation of probation trial, week or two.
Last time it was okay to plead guilty to the drinking, and now I can't.
I don't know, Miss Holly, on this case, was there ever an agreement that Mr. Santiago could plead just guilty to the violation for drinking?
No, we've never made an agreement. It just keeps getting adjourned because of the pending case in district court.
Yeah, we had agreed, and then she keeps adjourning it.
Well, I can leave it up to your honor's discretion. If he wants to plead to the drinking and we can just go from there, that's fine.
And then if he gets convicted of the domestic, then we can recharge him with a violation?
Yeah, because that, from what I see, that's adjourned to June. I looked it up and there's a settlement conference in June on that case.
So, Mr. Santiago, you understand if you just plead to the drinking, though, we can still violate you if you get convicted in district court?
Yes.
Okay. Ms. Underwood?
Your Honor, it would not be my choice to leave Mr. Santiago with another violation pending. I believe that Mr. Santiago is, I've tried to protect his rights against self-incrimination in this matter, Your Honor.
All right. So all right. So Mr. Santiago, you know, your attorney is rightfully trying to advise you in a way to protect your rights against self-incrimination. She's not doing anything wrong. But understand, if we dismiss count 1 and 3, Ms. Holly will reissue those if you get violated, if you get convicted. Do you understand? They don't go away.
Without prejudice?
Yeah.
Yeah.
So
I understand. I understand.
Without, let me ask it again. Without prejudice means she can violate you.
Yes, I understand. If I get found guilty on the domestic, yeah.
Ms. Holly?
That's correct.
Okay. All right. So you understand, Mr. Santiago, your attorneys advised you otherwise, but you wish to enter the plea.
Yes. Can I get sentenced?
Raise your right hand.
Can I please get sentenced today?
Nope. Sentencing is next week. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. So, Mr. Santiago, you understand the allegation that is remaining at this time would be that you consumed alcoholic intoxicants blowing a 0.08 by the Lenawee County Sheriff's Department records on February 16th of 23. Do you understand that?
Yes.
Okay, put your hand down. You're not charged with any drunk driving offense downstairs, are you?
No.
Okay, so Mr. Santiago, by entering this plea, do you understand that the maximum penalty could be up to 5 years in prison?
Sure.
Sure or yes?
Yes.
Okay, now Ms. Underwood has given you advice, but are you satisfied with hers or your attorney and the advice that she gave you?
Yes.
And you understand the advice she gave you, but you're choosing to act differently. Is that correct?
Yes. Yes.
Okay. All right. Now, do you understand that you do have a right to contest the violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes. Yes.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, Your Honor.
Do You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. You understand all of that?
Yes, Your Honor.
On the other hand, you understand that you do have a right to testify at your trial if you want to testify.
Yes.
All right, how do you plead to the charge that you violated the terms of your probation by consuming alcohol intoxicants blowing at 0.08 blood alcohol content on February 16th of 2023? Guilty or not guilty?
I'm guilty for the drinking.
Okay, so do you understand one of the terms of your probation is you were to consume alcohol?
Yes.
And did you consume alcohol on February 16th of 23?
Yes.
What did you drink?
I drank like a 40 ounce of beer, Budweiser, I think it was.
Okay, and you knew you weren't supposed to consume alcohol, correct?
Yes.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation or updated probation violation report. And I will set this for sentencing on May 5 at 8:15 in the morning. So, Mr. Santiago, Ms. Holly may speak with you before sentencing and do an updated probation violation report. We'll see you back here on May 5 at 8:15 in the morning via Zoom. Do you want to appear via Zoom for sentencing?
What was that?
Do you want to appear via Zoom like you are today?
Yes.
All right, we'll see you back here then. And let me see here. Miss Holly, what is the total owed on this file?
Do I have an amount on the bond?
I already paid for my bond.
Oh. Oh, 1,004.
All right. Did you already post the $1,004, Mr. Santiago?
Not for the probation violation.
All right, I'll set bond in the amount of $1,004 cash.
Yeah, I'm not paying that.
Okay.
All right.
Right, so, all right, we'll see you back May 5 at 8:15. Thank you, Ms. Underwood, and thank you, Mr. Santiago. You're all set.
Yeah. You have a good day. Thank you.
You too.
Okay, thank you.
Thank you. Okay, Mr. Martin, we're gonna come back to you now. All right. Nice trying to get him out today, Ms. Underwood, but anyway, Mr. Martin, let's see. Have you had a chance to speak with Mr. Malaro?
Yes, ma'am. We're gonna take the HIDA program.
Okay.